my lord, I think you know me well enough to know that something has occurred to me over the short adjournment. Three things, really. Firstly, I sent to your lordships a learned article on subjects from Mrs. Papadopoulos. I don't know if your lordships have got it. I've now handed it up.
Yes, thank you.
It's not necessarily germane to the present issue, but it does contain a learned consideration of subjects which
yes,
might be illuminated by. The second is that I have been asked by those instructing me, who are instructing me from Shanghai, that if you look at paragraph 9 of Amy Lee's first witness statement, which is in tab 4 of the bundle, she says, and it may not take very much further, it is common ground.
I don't think it is. Sorry, where are we looking?
Tab 4 of the second bundle. Actually, I think it's. No, I've been misled.
Maybe Lee is tab 1.
Tab 1. Yes, I think it's just my note.
Right.
Yes, it is tab 1. It's page 4. Sorry, I was page 4 rather than tab 4.
Yes.
Paragraph 9. It is common ground that on the 25th of August, the terms of a recap were agreed between DHL and the defendant. I've been asked just to draw that to your lordship's attention. I don't think it necessarily answers the question of whether it was a legally binding agreement. It doesn't, but it just goes to show that that was the position.
All right.
I thought your lordship should see that. And
what it says, paragraph 9, for what it's worth, is it goes on to say the recap then set out the various terms which, subject to the foregoing, had been agreed, and the issue is what was the effect of the foregoing?
Yes, your lordship is absolutely right, but I was asked just to show you how the matter arose. And the last point, I've been addressing your lordships on construction, really, what it is you're actually construing and what is the consequence of that construction. There was a second element, which is policy, and I hope I can summarize this in one sentence, which is, maybe there'll be a full stop somewhere, but one sentence. The correct procedure is for issues about the legal character of the relationship between the parties to be, in principle and absent clear language, to be determined by the arbitrators. And if the arbitrators err in law in their analysis of the, in this case, subjects, the means of redress before the courts should be under section 69 by way of appeal, and that section 67 is not an apt procedure, but is one bound inevitably to create duplication of dispute resolution tribunals, which is in principle to be avoided. I think it would have been better if I put it in 2 sentences, but...
Well, a paragraph is not a sentence. Yes.
It's a paragraph. My lords, unless I can assist your lordship further to the extent that I've assisted you at all, those are my submissions.
You could assist by giving me the reference, I mean not now, but send it in. You mentioned a decision by Mrs. Justice Cockerell about a different judge.
CVLC.
Yes.
Yes.
If you could give us the reference to that.
Yes.
I assume, there's no need to send a copy if it's on Bailey or any of the databases. We can find it if we need to.
My lord.
I was just going to it was just a curiosity from my point of view, just looking at the recap. I wasn't entirely, it may not be relevant to the legal issues which we're looking at, but I wondered whether the reference to shippers, receivers approval is picked up in the middle of page 10. Right in the middle of the page, between the two hole punches, because of is it the age of the vehicle?
Yes.
The age of the vessel,
yes.
sorry, which is the issue. Because this vessel is over 15 years old. Yes. And it is just so I understand the context, is that the point that shippers, receivers would have wanted some, or we thought that's the input they would have? It's because it's actually more than 15 years old.
Yes. And your Lordship is right. In fact, when I was introducing the recap, I was already feeling Time's winged chariot getting a bit close. Yeah. Your Lordship is absolutely right. I should have drawn that to your attention. And if I can, the risk of a tendentious comment, that's just the sort of point which is meat and drink to commercial arbitrators. But the answer is yes. Okay. My lords, I'm very grateful.
Thank you, Mr. Young. Mr. Holroyd.
Do you want another thing?
Oh, no.
You're all right.
My lords, I thought I'd begin by just looking at the grounds of appeal, because they set out helpfully, I think, the three strands of my learned friend's appeal as I understand it. It's tab 2 of the core bundle. And the first paragraph is the separability principle. It said the judge failed to give proper effect to it. And that does seem to be the main thrust of the submissions, and that's what I will very largely be concentrating on. The second is the one-stop shop dispute resolution presumption in contractual interpretation, and as is said here and as is correct, that is a principle of construction. And my submission broadly is that is an irrelevant issue, because what we're concerned with here is whether a contract's been agreed, not with what it means. The question of construction that arises is the construction of the subject. So that's limb 2 of the appeal. And limb 3 of the appeal is that the judge erred in law in failing to construe the parties as a whole. And I understand that to be a reference to the other side's case that the subject has to be read together with the nomination clauses of the pro forma, and that when you do that, there's a not to be unreasonably withheld qualification on the subject. So that's the third limb of the appeal. And then 4 is just a reference to the skeleton argument as a whole. Before I get into the separability principle, I just thought I'd say something about the Section 69 application, how I see the interrelationship of the two. Mr. Young said that the same judge shouldn't decide the permission on a Section 69 and the substantive appeal. But the hearing before the judge was a rolled up hearing of the permission application, and if permission was given, the substantive application on Section 69. That's referred to in paragraph 5 of the judgment, which had been ordered by Mrs. Justice Cockerell. That's also mentioned in paragraph 5 of the judgment. So there can't be any objection here to the judge having dealt with Section 69, because he was meant to.
He has in fact heard the appeal.
Yes. Yes, he has. The judge gave leave to appeal on the Section 69, and he decided it in my submission. He decided in paragraph 133 of the judgment that there had been an error of law.
Well, he said how he would have decided it. He didn't decide it because he didn't get there in view of his conclusion on Section 67.
I accept that. I was going to
where does that leave us if we were to allow the Section 67 appeal? You say what? We send it back to the same judge, or we?
It's never going to happen that way, my lord, in my submission, because the issues which arise on the Section 67 include the issue of contractual interpretation that arises on the Section 69. And that is because, in the context of construing the subject, which is what we have to do on this application, One of Mr. Young's arguments, which is the third one in his grounds of appeal, is that you have to read the charter party as a whole and look at the pro forma, and that the subject is to be understood as including a not to be unreasonably withheld provision. And that contention of his is relevant in whether the subject is a precondition to contract, which is obviously the central area for consideration for the Section 67. So your lordships do have to decide that question, and that is the same question that arises on Section 69 as to whether there is a not to be unreasonably withheld.
Well, we may have to decide it as part of deciding Section 67, but suppose we decide it adversely to you so that the appeal succeeds, and then the Section 69 therefore becomes a live point. Mr. Young's point is that it is only a judge in the commercial court who can decide Section 69 because there is no order deciding it, and therefore this court has no jurisdiction. Although it may be that what we would say in the judgment would give a pretty clear steer to somebody, whether Mr. Justice Jacobs or anybody else, as to how it should be decided, depending on what we decide that we need to deal with in the judgment. But formally speaking, if we get to Section 69, it's got to go back, hasn't it?
My Lord, in my submission, that's an unnecessary procedural complication in circumstances where the commercial court judge has already said how he would have decided it if it arose, and in the circumstances postulated, it did arise, even though he didn't think it did. But he did give his view on it.
But he hasn't given leave to appeal to this court, which is essential for us to decide it, isn't it?
But there would be an issue estoppel arising from your decision as to what the contract meant and whether there was or wasn't a not to be unreasonably withheld provision, which is the only thing that the Section 69 is about. And the judge held that he would have set aside the award under Section 69 if the Section 67 hadn't succeeded. And my submission to your lordship is that if in these scenarios, which I will of course endeavour to persuade you don't arise because the Section 67 does appeal, but if it does succeed, but if we get there, my submission is that you should set aside the award or leave the award set aside on the basis that the Section 69 inevitably succeeds on the basis of your findings in the scenario that we're discussing.
All right, well, if we get there, we'll have to puzzle that one out.
Yes, my lord. Separability. It's common ground, I think, that the Section 67 issue is whether an arbitration agreement was concluded. And when I say whether an arbitration agreement was concluded, I mean whether a contract to arbitrate was entered into, so a legally binding agreement. I think it's common ground that that is the question on which the outcome turns, whether a binding arbitration agreement was concluded. I say that, I'm looking at paragraph 4 of my learned friend Skeleton, where he says, the discrete and only question on this appeal is whether Mr. Justice Jacobs was right in law to hold that the parties' agreement to refer disputes to arbitration was not a binding arbitration agreement as a matter of law, which, leaving aside the tendentious use of agreement, first use of agreement in line 2, I think does identify, it is intended to identify correctly that the key question is, was a binding arbitration agreement entered into? The separability principle is a principle to the effect that for some purposes, an arbitration agreement within a contract, or arbitration clause within a contract, is to be considered in law as giving rise to a separate contract from the main contract. The core purpose and function of the doctrine is to protect a validly concluded arbitration agreement from ceasing to be binding or effective or valid because of some defect in the main contract. The separability principle is a legal device which prevents the conclusion following as a matter of law that because the main contract is void or illegal or in some way defective, it necessarily follows that the arbitration agreement disappears as well because they're a part of the same contract. That is the chain of reasoning or the legal consequence which the separability principle exists to prevent. Because in this context, the arbitration agreement will be viewed as a separate contract and therefore it doesn't disappear or have never been effective or whatever the particular defect is that has caused a problem with the main contract. But the separability principle starts, in my submission, from the assumption that a valid and binding arbitration agreement has been concluded. The purpose of the principle is to protect that agreement or that contract, that legally binding engagement, by viewing it as a separate legal thing, and to cause it to continue being binding and effective. If there has not been a binding arbitration agreement in the first place, then there's nothing upon which the separability principle can work. There is nothing that can be kept separate from the main agreement. And so in my submission, the separability doctrine is not engaged or does not materially assist in relation to the question of whether an arbitration agreement has been concluded in the first place. That question is a question that falls to be decided by reference to ordinary principles of contract formation, offer, acceptance, and so on, which determine when parties have entered into a contract or when they haven't. So my submission essentially is that Mr. Young's whole approach to the separability principle is wrong and misguided, and it's an attempt to apply it in circumstances for which it's not intended and does not assist. And there is nothing unorthodox about, as the judge said, about the conclusion that the same circumstance can result in neither the main contract nor the arbitration agreement having been agreed in the first place. There's nothing at all unusual about such a conclusion. It's paragraph 79 of the judgment where the judge said that that wasn't anything unusual. The allegation that the main contract was never assented to will, if made out, almost always mean that the arbitration clause within it was also never assented to. And I will make that good by reference to authority. Most of the authorities you lordships have seen by now, but there are one or two that I would like to take you to. The key authorities on the separability principle are not in conflict with my submission that an allegation that the main contract was never assented to will almost always, if it's correct, mean that the arbitration clause was never assented to either. So there's authorities that I will show you, but it's also obvious as a matter of theory and of ordinary interpretation of what commercial parties are doing when they negotiate a contract that has an arbitration clause in it. Commercial parties treat the arbitration clause as part of the contract they're negotiating, which for them is what it is. It's very likely, in most circumstances, it's not inevitable, because of course it's possible for parties to enter into an ad hoc arbitration agreement, to enter into an arbitration agreement before they've concluded a main contract. Of course that's possible, but it's not the ordinary course. And when parties send backwards and forwards drafts of a written agreement that hasn't yet been signed, that has an arbitration clause in it, one would need some unusual facts to reach a conclusion that there's some process by which that clause has become a binding contract, whereas nothing else has. That one would need some express manifestation of an intent to that effect by the parties. And certainly something much more than sending drafts backwards and forwards with neither party suggesting changes to the arbitration clause. So my overarching submission is that the reliance on the principle of the separability principle is misguided, and it's the wrong thing to be looking at. What one should be looking at, in my submission, are the authorities on the meaning of the subject, and the authorities on in what circumstances will a court hold that notwithstanding some express wording, such as subject to contract or any of the various variants, that despite such wording, a binding contract nevertheless arises as a result of the parties' subsequent dealings. Those are the authorities that are relevant to the question before this court in my submission, and not the authorities on the separability principle. I said I'd show you some authorities. Harbour and Cancer is obviously the seminal decision, and I would like to show you briefly the first instance decision. Just by way of background, my learned friend largely covered this, but Hayman and Darwin established that an accepted repudiation of the main contract would not bring the arbitration agreement to an end. But what had not been determined prior to Harbour and Cancer was whether initial invalidity of the main contract would bring the arbitration agreement to an end or cause it to cease to be effective. And Harbour and Cancer was the decision that held that initial invalidity didn't impair the arbitration agreement. And Mr. Justice Steyn, as your lordships have already been informed by my learned friend, he very much wished to reach the same result the Court of Appeal did, but he felt constrained by authority. So what he held was that, in general, initial invalidity is not enough and the arbitration clause will survive. But because of a Court of Appeal decision, initial invalidity due to illegality, he felt he couldn't distinguish a Court of Appeal authority, so he held that that species of initial invalidity did impair the arbitration agreement. And the Court of Appeal didn't agree with that last part. But apart from that, they did agree with him. And there are two passages I wish to show you. It's in my additional authorities bundle at tab 4. So I'm showing your lordship's authorities really...
I don't think I have this.
Oh.
I've received two versions of your...
I've got...
bundle.
You have mine, I have.
Oh, are there? My lordship, sorry, it may be that the latest version is not reached you.
I've got... You have mine. You have mine.
I'm sorry, I'm told it has been sent to the court, but there may be a administrative delays.
I've got it.
This is Harbour in first instance.
Yes, I've got
Steyn.
it.
Oh, right.
Oh, well.
Well, I think I'm the only one who has it.
Is it just my lordship as well?
It seems to me, yes. So probably I'm sure you sent it, but if it got through to me, I didn't notice it. Thank you very much indeed.
So the two purposes for which I'm showing your lordship authorities are to make good my submission as to what the purpose of the separability doctrine is, and secondly, to show that there's nothing unorthodox about the suggestion that lack of assent to the main contract will also mean there hasn't been assent to the arbitration agreement. So Mr. Justice Steyn's judgment on page 83, there's a highlighted paragraph on the right-hand column where he says, this case is concerned with a different matter, namely the scope of the principle of separability of the arbitration clause in an integrated written contract. That principle is legal shorthand for a group of rules which govern the circumstances in which the arbitration clause remains binding despite the invalidity, discharge, termination or rescission of the contract. So the wording there, remains binding, obviously presupposes that it's binding in the first place. And then the second passage is on page 86. On the right-hand column, under the subheading circumstances directly impeaching the arbitration agreement. And this is where language of impeaching comes from. I'm not sure whether earlier cases used this or not, but it's certainly used here. The foundation of an arbitrator's authority is the arbitration agreement. If the arbitration agreement does not in truth exist, the arbitrator has no authority to decide anything. Similarly, if there's an issue as to whether the arbitration agreement exists, that issue can only be resolved by the court. For example, if the issue is whether a party ever assented to a contract containing an arbitration clause, the issue of lack of consensus impeaches the arbitration agreement itself. Similarly, it can be the arbitration agreement can be directly impeached on the grounds that the arbitration agreement is void for vagueness, for mistake, avoided misrepresentation, etc. All such disputes fall outside the scope of the arbitration agreement, no matter how widely drawn, and are obviously outside the arbitrator's jurisdiction. The scope of the principle of the separability of the arbitration agreement only arises for consideration where the challenge is directed at the contract which contains an arbitration clause. So there we have a statement that lack of assent to the main contract will directly impeach the arbitration clause, and that was the analysis of Mr. Justice Steyn. His reasoning was expressly upheld by Lord Justice Ralph Gibson in the Court of Appeal. That is, it's on page 709F of the report of the Court of Appeal decision. Maybe we should just turn that up. It's tab 3 of the main authorities bundle. Where at paragraph F on page 709, Lord Justice Ralph Gibson says, "For my part, and for the reasons which follow, I would uphold the reasoning and conclusions of Steyn J on all aspects of his judgment, save for his final conclusion that he was bound by the decision in David Taylor and Barnett." So, in Harbour and Cancer in the Court of Appeal, one has Lord Justice Ralph Gibson upholding Mr. Justice Steyn's reasoning, and also Lord Justice Hoffman at paragraph, the passage your lordships were shown on page 723. I'm not suggesting he directly upheld Mr. Justice Steyn's reasoning, but the substance of the passage at 723G is very similar to Mr. Justice Steyn's, where Lord Justice Hoffman said, "It seems to me impossible to accept so sweeping a proposition. There will obviously be cases in which a claim that no contract came into existence necessarily entails a denial that there was any agreement to arbitrate, non est factum, or denial that there was a concluded agreement, suggest themselves as examples." There's no difference in substance there from what Mr. Justice Steyn was saying. Harbour and Cancer is the seminal decision on which Section 7 was. I'll show your lordships the DAC report, but they say in terms that the principle that they're enacting was already part of the common law and refer to Harbour and Cancer in that regard. A second decision, which we don't have itself, but we have it quoted in one of the other decisions, is a decision of Mr. Justice Coleman called V Networks in 2004. This is quoted in the UR Power case in tab 5 of the authorities bundle. It was also relied on by Mr. Justice Jacobs at paragraph 77 of his judgment. And the relevant quotation is in paragraph 36 of Mr. Justice Gross's judgment in this case, the UR Power case. And what you can see, he sets out a long quotation from paragraph 19. The passages I wish to highlight are there's a sentence about a third of the way down that begins, "This jurisdiction was held to exist," that is the jurisdiction of the arbitrator to decide whether the main contract was void or illegal or whatever. "This jurisdiction was held to exist, provided always that there was a binding agreement to arbitrate. The essence of the separability doctrine was that of insulation of the agreement to arbitrate from the matrix contract to the effect that the agreement to arbitrate would not be rendered void or invalid or avoided solely because the main contract was void or invalid or had been avoided." Very similar to the way Mr. Justice Steyn expressed it in Harbour and Cancer. And further down in the same quotation, the sentence that begins, however, where one of the parties to the arbitration had not agreed to become a party to the matrix contract, it could invariably be said that the party in question was not bound by the arbitration agreement. That's quite different from statutory illegality, which renders the matrix contract void. So again, we have a judge saying in terms that if there's an allegation that a party hasn't agreed to the matrix contract, that's going to bring with it an allegation that he's not bound by the arbitration agreement. And once one has a dispute as to whether a party has agreed to arbitrate in the first place, that is outside the separability doctrine. It's not, one doesn't get into what the separability doctrine is for, which is protecting a binding arbitration agreement from being rendered invalid by something to do with the main contract. That's a different thing from the question of whether there was initial agreement to arbitrate.
Paragraph 20, just over the page, in the extract from V Networks,
Yes.
provides a view, presumably which you agree on the proper interpretation of Section 7.
Yes. Yes, leaves intact the requirement that the arbitration agreement should be valid and binding. Absolutely, I was going to make that submission when I come to the statute.
Yes.
The next case, again, is one that's not in the bundle but is quoted from in Anchor at tab 10, which is the Sul-America case, Lord Justice Warwick. If you could turn to paragraph 63 of the judgment, please. There's a quotation. Lord Justice Warwick summed up the position clearly when he said this in the Sul-America case. And I believe he was giving the judgment to the court, but I should probably check that. The concept of separability itself, however, simply reflects the parties' presumed intention that their agreed procedure for resolving disputes should remain effective in circumstances that would render the substantive contract ineffective. Its purpose is to give legal effect to that intention, not to insulate the arbitration agreement from the substantive contract for all purposes. So I'm relying on this for, again, a similar statement as to what the purpose of the concept is, which is protecting a valid agreement from being rendered invalid. And it's not for all purposes that one treats the arbitration agreement as different. And then there's Fiona Trust, which your lordships have been referred to extensively. And in my submission, Fiona Trust doesn't say anything materially different from the earlier authorities. It's not a revolution in what the separability principle means. Its significance was largely in relation to a different issue, which is construction of arbitration clauses and whether one should construe them as being wide enough as a matter of their terms to embrace initial invalidity of various types. And the House of Lords, Lord Hoffman in particular, gave a very strong indication that they should be construed extremely widely, because this is what sensible business people are presumed to want, to have a single tribunal and so on. But that element of it is not relevant to the decision here, which is whether there was an agreement to arbitrate in the first place. And on that topic, Fiona Trust was not a case of initial invalidity. It was a case of purported rescission for bribery subsequently. So there was no dispute in Fiona Trust that there was a binding arbitration agreement originally. The question was, could it then be rescinded because there was an entitlement assumed to rescind the main contract? And in my submission, none of the passages that you've been referred to or could be referred to alter in any material way what the principle of separability is about and the circumstances in which it applies. And in particular, Lord Hoffman, at paragraph 17, says, of course, there may be cases in which the ground upon which the main agreement is invalid is identical with the ground upon which the arbitration agreement is invalid. And he gives an example of a forged signature. But the principle is exactly the same. You look at the circumstance which is relied on, and if it's a circumstance which goes to showing that there was no assent to the arbitration agreement in the first place, well then of course there's not going to be an arbitration agreement. You can't create one out of nothing where the parties have not actually agreed it. And that's said very clearly by Lord Hope at paragraph 34, where he says that this case is different from a dispute as to whether there was ever a contract at all. As everyone knows, an arbitral award possesses no binding force except that which is derived from the joint mandate of the contracting parties. Everything depends on their contract. And if there was no contract to go to arbitration at all, an arbitrator's award can have no validity. So, where the arbitration agreement is set out in the same document as the main contract, the issue whether there was an agreement at all may indeed affect all parts of it. So that's not at all different from any of the earlier authorities. The sentence which I, as well as my Lord Justice Snowden, thought that my learned friend would particularly rely on towards the end of paragraph 18, also when read carefully, doesn't change the picture at all in my submission. This is the sentence that's marked, even if the allegation is that there was no concluded agreement, for example, that terms of the main agreement remain to be agreed, that's not necessarily an attack on the arbitration agreement. If the arbitration clause has been agreed, the parties will be presumed, and so on. The key question is still, has the arbitration agreement been agreed? And one can envisage circumstances where an allegation that there was no concluded main agreement would still be arbitrable. Two that I can think of are, firstly, a circumstance where there's an umbrella contract containing an arbitration agreement, so two parties agree that all contracts between them shall be governed by a standard set of terms, which includes an arbitration agreement. And they then are making regular trades, each individual trade coming into existence with communications between traders, and if there's a dispute as to whether a set of exchanges between a trader gave rise to a contract of whatever it is, sale, such a dispute would be arbitrable because the parties had agreed an arbitration agreement, and that would be arbitrable. Another circumstance, probably, is where parties agree, let's say, a written document which contains an arbitration clause, where the arbitration clause is clear and properly drafted, but the parties, let's say, purport to agree the main contract containing the arbitration clause. Maybe they sign it to manifest agreement, but later on one of the parties alleges that the terms of the main contract are too uncertain to give rise in law to a binding contract. In those circumstances, I suggest there would be an obligation to arbitrate because the uncertainty wouldn't affect the arbitration agreement, which the parties had purported to agree contractually along with the other terms. And so therefore the issue of whether the main contract was too uncertain or not, I suggest, would be arbitrable. But these kinds of circumstances are relatively unusual. In the usual circumstance, where the issue is simply, has agreement been reached? Has the stage of negotiations been reached where the parties intended to enter into a binding contract? If that's the question, then usually, in a very large majority of cases, that's going to be the question that determines whether there's a binding arbitration agreement as well, because the parties will have been dealing with the things together in one document, and they will have been treating the two things as coterminous. So in my submission, none of the authorities assist my learned friend, and indeed quite the opposite. When one looks at what the purpose of the severability doctrine is, they assist me, and they show that it's not the relevant source of law that one should be looking at for an issue such as the one that arises in this case. Section 7 itself, I said I'd take you to it. I'd like to refer you to the DAC report, which is at tab 12. Paragraph 43 is dealing with section 7. And it starts by saying the clause sets out the principle of separability, which is already part of English law, see Harbour and Kansas, which is also to be found in Article 16.1 of the Model Law, regarded internationally as highly desirable. And then they explain why they think it's separate from the doctrine of entitlement to rule on own jurisdiction, so they've dealt with that in a different place. And then they say in 44, in the draft clauses, we inserted a provision to make clear the doctrine of separability did not affect the question of whether an assignment of rights under the substantive agreement carried with it the right to arbitrate. This is now omitted as being unnecessary, since we've redrafted subsection 1, that is of section 7, in order to follow the relevant part of Article 16 of the model law more closely, and to make clear that the doctrine of separability is confined to the effect of invalidity, etc., of the main contract on the arbitration agreement, rather than being a freestanding principle. So the reason I've drawn your attention to this is firstly that the clause was intended to enact something which was already part of English law as per Harbour and Cancer. Secondly, that it's very similar to the model law, and I will later show your lordship's Singapore case, which Singapore being a model law country, where they have a very similar principle of separability. Thirdly, separability is not a freestanding principle. It's a legal device that the courts have invented for the purpose that I already outlined, for the purpose of insulating a binding arbitration agreement from being affected by invalidity, etc., of the main agreement. And then if we actually just turn to the wording of Section 7, which I know your lordships have already looked at. My key point on this, which we've already touched on, and the court's questioning of my learned friend also touched on, is this principle presupposes a binding agreement to arbitrate. And I think ultimately my learned friend conceded that when being questioned as to what the meaning of the words arbitration agreement were. He did, in my understanding, eventually concede that it meant a binding arbitration agreement, as in a contract to arbitrate. Unless otherwise agreed by the parties, an arbitration agreement which forms or intended to form part of another agreement shall not be regarded as invalid, etc., because that other agreement is invalid, etc., and it shall for that purpose be treated as a distinct agreement. This is a provision designed to protect something which is valid, or it would otherwise be valid, from being rendered invalid by the circumstances referred to. And in my submission, that point is really fatal to the way that Mr. Young puts his case, because his case lays great emphasis on the word agreement, but he's reluctant to say that what that means is a contractual agreement. He's trying to rely on agreement, as he calls it, which is not a contractual, or at least on my case, is not a contractual agreement. It's a, if we use the word agreement, agreeing what terms the parties would be willing to contract on if and when they conclude a contract. But that, of course, is not the same as actually concluding a contract. And in the principal part of his skeleton and in his submissions, Mr. Young avoids directly addressing, for the most part, the question of whether there was a concluded main contract. He's keen to say to your lordships, well, that doesn't matter, it doesn't really matter, because the question is arbitrable. The question of whether there is or there isn't is arbitrable. And that's how he puts it in paragraph 41 of his skeleton, that the question is arbitrable. But you can't dodge the issue in this way, you can't finesse it in this way. If no main contract was concluded, as my case is because of the wording of the subject, then the contention that nevertheless an arbitration agreement was concluded is an unusual and a difficult one.
It's not impossible.
It's not impossible.
I mean, it's what Lord Hoffman envisaged in paragraph 18 that we just looked at, isn't it?
He envisaged that it's possible, and of course it's not impossible, but you need some particular facts on which to base a credible case that there was offer and acceptance for concluding a contract to arbitrate. And there are no such facts in this case. Because the circumstances of in this case, at least on my case, are not that the parties intended or even purported to conclude a main contract, but it was ineffective or something for some reason. The circumstances here are the parties never intended to enter into a main contract at all. The purpose of the subject was specifically to prevent that, and that subject was never listed, so they never intended to enter contractual relations at all. It's not a case, it's not even a case of purporting to enter a contract, which is where Mr. Young's first proposition, as he put to your lordships, and he was picked up on, well, what do you mean by purport to enter? a contract. And my submission is, whatever he did mean, it can't extend to these circumstances in this case, if I'm right about what the subject means. That's really what the key question is.
What are Mr. Young's clients supposed to do in the circumstances where they find themselves, where they say that this is a performance condition? And if they're right about that, then there is a concluded contract.
Yes.
And it is got an arbitration clause in it.
Yes.
So they have to start an arbitration, don't
they?
They can't.
Well,
how can they not do that if their case is that it's a performance condition?
What they should do firstly is not sue us, because it's perfectly obvious that they're not going to win in these circumstances. Whatever the analysis is. When you look at the facts described in the judgment,
That's the cry of
you just
every defendant. In every case.
if you read the facts, where it's perfectly clear what happened, everyone was waiting around, my clients were trying to press the shippers ultimately said we don't want the ship, and we passed that on and said, sorry, we're not, the ship is free, we're not lifting the subject. How on earth could that give rise to a liability on my clients for repudiating a charter? It's the express basis on which everyone was acting that there wasn't a concluded contract, and that until the sub is lifted, that's it. It's just
Right,
bad
that's
luck.
the cri de coeur. What's the answer?
Okay, that's the cri de coeur. So if they want to argue that there is a concluded contract and a performance obligation, then they have to arbitrate, yes. And if they're right, then that's good for them. But if they're wrong, then the award is vulnerable to a Section 67 application, a successful Section 67 application.
So it is a bit odd, isn't it? I mean, you've got a situation where you should only be going to the arbitrator if you're right, but if you're wrong, you shouldn't be going at all.
But that's the inevitable consequence of the structure of the Arbitration Act and the way it works, and the fundamental principle that the arbitrators can't create their own jurisdiction by holding that they have it. That always has. If there's a debate about whether there's an arbitration agreement, that always ultimately has to be resolved in the court if parties, exercise all their rights of appeal.
Well, I suppose what they could do is write to you and say, we think we're right and there's an arbitration agreement. What do you think? And can we make an ad hoc agreement to refer that issue to an arbitrator?
Yes.
Or a tribunal of arbitrators.
Or
alternatively, can we agree without prejudice to anybody's position that the court will decide it?
Absolutely.
But,
those options.
there are ways if people want to be pragmatic. But
absolutely.
That doesn't seem to have happened in this case. Partly, perhaps, because of internal problems on your side.
There were undoubtedly internal problems on my side. It's unfortunate because one can't help feeling that if we had made submissions, things might have ended much earlier. But my learned friend, on a related point, my learned friend refers to two-stop decision-making as being a terrible thing. Of course, that is the current position. I mean, the points my learned friend's arguing, they were all run in the Pacific Channel and decided against him, against the argument of 9 years ago or so. So the basis on which everyone's been operating is the way I say things are. And there is no great problem with the number of Section 67 applications. My learned friend referred to the Law Commission consultation on the Arbitration Act, and I just looked at what they say about Section 67. And although they do propose a reform to make it not a de novo hearing, but a review, they do accept that there isn't actually any practical problem. They say there are pragmatic arguments against the need for reform to exclude the possibility of a de novo hearing. First, Section 67 is only invoked in a tiny percentage of cases. There were only 15 applications in 2020 to 21 and 19 in 2019 to 2020. This is down from 56 in 2017 to 2018. This is probably fewer than 0.5% of all English-seated arbitrations in those years, and the statistics are based on the Commercial Court reports.
Well, the proposal for a review has its own illogicalities, because on your case you would say, if we never agreed to arbitration, why should we be confined to a review of findings of fact by an arbitrator whose jurisdiction we never agreed? But that's really a question of policy for the Law Commission and Parliament rather than for us.
I thoroughly agree with the Lordship and invite him to submit a response, as it's open till, I think, December. But yes, that is essentially a policy question, whether the argument from principle is strong enough. and I have great sympathy with the argument from principle, but the Law Commission, in their provisional view, don't. But that's sort of by the by from the issues for today. But my point in referring to the statistics is that the accepted position, certainly since Pacific Champ, is if there's a dispute as to whether there's a concluded contract, it's very likely to ultimately have to be decided by the court unless the parties go down some ad hoc route.
And the principles which the court is applying to that are ordinary principles of contract formation, so
Yes.
offer and acceptance, intention to create legal relations.
Yes.
And you say what? That intention to create legal relations is excluded by the subject?
Yes.
Or is it as simple as that, or do you say more than that?
One can certainly summarise it that way, my lord. The leading case on contract formation against a subject to contract type wording is the RTS and Molkerai Alice Muller case, which is in tab 6 of the bundle. And this is a case about where there was express subject to contract wording and things nevertheless were partly implemented, and the question is, has a contract nevertheless come into being despite the express wording? And we don't need to look at the facts at all, but for the principle at paragraph 45, the general principles are not in doubt. Whether there is a binding contract between the parties, and if so, upon what terms, depends upon what they've agreed. It depends not upon their subjective state of minds, but upon a consideration of what was communicated between them by words or conduct, and whether that leads objectively to a conclusion that they intended to create legal relations and had agreed upon all the terms which they regarded, or the law requires, as essential for the formation of legally binding relations. Even if certain terms of economic or other significance have not been finalised, an objective appraisal of their words and conduct may lead to the conclusion they did not intend agreement. Then at paragraph 49, this is the Supreme Court, the reference to the judgment of the Court of Appeal in Pagman, Lord Justice Lloyd. This is quoted approvingly by the Supreme Court. In order to determine whether a contract is being concluded in the course of correspondence, one must look at the correspondence as a whole. Even if the parties have reached agreement on all the terms of the proposed contract, nevertheless they may intend that the contract shall not become binding until some further condition has been fulfilled. That is the ordinary subject to contract case. And later on at 56, because then there's the question of whether the subject to contract provision is waived, whether in such a case the parties agreed to enter into a binding contract waiving reliance on the subject to written contract term or understanding will again depend on all the circumstances of the case, although the cases show that the court will not likely so hold. So those are the principles upon which I suggest you should be approaching this case. And of course, the key question is, what does the subject mean in this case? And that is, for that, I rely heavily on the outcome in the Leonidas, where a very similar provision, suppliers, receivers approval, as opposed to shippers, receivers approval. So one of the two subjects was the same and the other was very similar, where the matter was analysed in depth by Mr. Justice Foxton. I've set out in my skeleton what I rely on, and I won't go through it in detail.
Mr. Young says you can't draw too much on that because Mr. Justice Foxton says it all depends on the particular facts, and the particular facts in those cases were that the bookends were both preconditions, and the mixing metaphors jam in the sandwich was
yes.
Took its flavour from that.
Yes, that point doesn't really go very far when one looks at the actual reasoning of Mr. Justice Foxton, which I will take you to now, if that's all right. So if we turn to the Leonidas, let's tab 9. Because this is a very thorough judgment which analyses things with considerable care, and there are quite a number of strands to the reasoning, which certainly go much further than it's in the middle of things which are a precondition. The consideration starts really at 41 with a heading, the applicable legal principles, and you'll see reference to the case I just referred your lordships to of the RTS flexible systems, which obviously I won't read again. And again, the Pagnan feed quotation is set out by Mr. Justice Foxton, and he's dealing with subject to contract generally before later getting to charter parties, and he deals with paragraph 44. He's on subject to details, which is the Junior K case that quite some time ago in 1988 held that is a precondition, and Mr. Justice Steyn, the quotation, the thrust of it is essentially that this is what people need to know where they are, and this is a device which tends to avoid disputes, and the assumption of those in the shipping trade that it is effective to make clear that there is no binding agreement at that stage ought to be respected. That is subject to details. Then at 46, he goes on to, he says the legal effect of subject to contract, subject to details is therefore to enable either party to avoid entering into contractual relations. He says similarly no contract when subject to board approval, and there's a reference to a decision of my Lord Justice Mayles in the High Court, Goodwood Investments, which was to do with board approval. 47, when the event on which the entry into contractual relations depends is a decision by one or both parties to undertake a legally binding commitment, there's no room for the argument that some form of preliminary agreement comes into existence, imposing an obligation on one or both of them to seek to complete the bargain. Then at 52, he turns to, each case will depend on its own facts, which is what my learned friend relies on. A subject is more likely to be classified as a precondition if it involves the exercise of personal or commercial judgment. So those were, until now, were all general principles, but now he turns to the specific context of charter party negotiations, which is in 53. He says there's a particular feature of negotiations for the conclusion of contracts for the employment of ships, and he refers to this terminology of concluding on subs, generally referred to as an agreement on subs, an expression which signals that there are preconditions to contract which remain outstanding. The conclusion of binding contract is seen as dependent on the agreement of the relevant party or parties to lift, i.e. remove, the subjects. And there's a quotation from Carver, which sets out this general, not exactly practice, but the way things work typically in the charter party market. The parties may agree the terms of the charter party. One such term may be a condition precedent that, unless and until the precedent is satisfied, no binding contract comes into being. In charter party negotiations, such conditions precedent are often referred to as subjects. Satisfaction of those contracts conditions precedent is referred to as lifting subs. And there's a similar passage in Wilford on time charters, which is not set out here, but is set out by the judge and relied on. I'll just find that. Paragraph 85 or 86 of the judgment. 86. The judge sets out the passage from Wilford, which is, in practice, parties very often indicate that they do not intend to make a binding contract by saying that their agreement is subject to conditions. To say an agreement is on subjects means that it's not binding until the subjects in question have been lifted. Generally, only when all subjects are lifted does an agreement become a binding contract. At that point, the ship is fully fixed. So, Mr. Justice Foxton is relying on the...
There's one notable absentee here. Is there anything that helps either party in voyage charters?
I'm afraid I can't remember, my lord. I can't have thought it was as helpful as the ones that were cited, otherwise I would have put it in. But equally, my learned friend has not relied on it, so it can't be that helpful.
I would never rely upon it.
That's why I asked Mr. Hallward.
I did actually look and see what the 5th edition said. It quoted the Leonidas. I'm not sure it's going to enlighten your lordship any further. It's put a little query as to the outcome of this case.
Yes, all right.
But there's nothing in it.
No, I just wondered.
The 6th edition may be different.
Paragraph 54 is important. It's when a subject is only resolved by one of the parties removing or lifting it, rather than occurring automatically on the occurrence of an external event, such as granting a license, it's more likely to be a precondition. Now, of course, I say that our subject is one that is resolved by lifting, and there's express reference in the fixture recap to charterers lifting subs, and that's a point that goes further than anything that was in the Leonidas. There wasn't such language in Leonidas, but Mr. Justice Foxton nonetheless held that it worked in the same way. The suppliers, receivers, subject in his case.
So Holroyd, it's one of the things that slightly puzzles me about this is, on the basis of what you're submitting there, really, what any of these subs mean if they're on the precondition side of the line, what any of the words used in them, they don't really amount to anything, do they?
That's exactly right, and that's what Mr. Justice Foxton held. There's a section later on in the judgment where he says expressly that when analysed legally, that is effectively what it comes down to.
I see. Thank you.
So I'm not able to find it immediately.
Don't worry, Mr. Wall.
Yes, it's paragraph 79. It's the marked passage in paragraph 79.
Yes, I see.
I'm back on paragraph 55, where there's reference to long-standing authority about the meaning of subject to stem, which my learned friend conceded is a precondition to contract. And this was a 1921 case, the KKK case. And towards the end of paragraph 55, Mr. Justice Watson makes the point that it isn't the actual procuring of a stem that matters, it's the confirmation by the charterer. And actually, it doesn't matter legally whether he's got a stem or not. It turns on whether he confirms the contract. The paragraph 57 is where Mr. Justice Foxton makes reference to the sandwich point, that it would be odd if the middle ones were different from the outside ones. But even in that paragraph, he makes further points, and he says that the first three subjects, which includes suppliers and receivers approval, all relate to matters which bear on the commercial desirability for the charterer of entering into the charter party. Can he procure a cargo which can be loaded on and discharged? Is the vessel acceptable to suppliers and receivers? In my opinion, Mr. Boven-Siepen is correct in submitting that subjects which relate to commercial desirability are qualitatively different from matters such as obtaining import and export licenses. And then he says, and this is an important statement, there are other reasons why I prefer Mr. Boven-Siepen's submission that the supplier's approval subject in its ordinary usage is a precondition and not a performance condition. So he's saying expressly that irrespective of the sandwich point, in his judgment, in its ordinary usage, it's a condition precedent. And then there's a long discussion of the uncertainty of the exact meaning of, if one is making it a performance condition, then it becomes very important, what exactly does it mean? Who is the supplier? Who is the receiver? And there's a long discussion about the uncertainty of what it would, if you were trying to give a contractual effect to it, what it would mean. And one of the parties at one point was trying to put in expert evidence to say that it meant the terminal from which the cargo was loaded, but that ultimately they gave up on trying to do that, and because the alternative is that it means the contractual seller. And the same uncertainty can arise, of course, in relation to the word receiver, whether it's the contractual buyer or whether it's the terminal at which the cargo is physically received. And so at 60, Mr. Justice Foxton says the degree of uncertainty supports the view that, well, so it means it's unlikely it was intended to create a contractual obligation. As to how he would construe it, he would give it a wide construction. This is in 61, of meaning anyone, all those approval which the charterer commercially wishes to obtain on the supply side, with the receiver's approval subject having equivalent meaning so far as the delivery side is concerned, and it can only be said to have been satisfied when the charterer lifts or waives the term. And that harks back to the previous passage I drew your Lordship's attention to, that if the subject is one which is satisfied by being lifted, that is appointed to a precondition and not a performance condition. So I think I'll skip forward. So what happened in the Leonidas was that a deal was done, I think it was on a rate of demurrage, or some commercial benefit that was negotiated in exchange for lifting 3 of the subjects. And there was just the supplier's subject left. And it wasn't ever lifted. And so the case is put, well, you were under a duty to use reasonable endeavours to get the supplier's approval. That's what the dispute was. And there was heavy reliance on, well, the fact that a deal was done in relation to the previous, the other subjects, so surely it must, leaving only one of them must have meant to be intended to have a legal consequence and create a duty to go and get the approval. That was the case that was put, and it failed. And we're now moving on to the bit of the judgment at 77, which is saying why it failed, is moving on from whatever the general meaning of such subjects are, but even in the factual circumstances of this case, against that background, why Mr. Justice Foxton still thought that it remained a precondition. It didn't change its character and become a performance condition when that commercial deal was done to lift the other subjects. So at 77, there's reference again back to the RTS case and the fact that when parties are negotiating on a subject to contract basis, it won't likely be inferred that they've stopped doing that. And he says it must be a rare case in which something short of the parties proceeding to perform the agreement which they negotiated, subject to an unsatisfied precondition, would be sufficient to constitute an implicit agreement to waive or remove that precondition. And he goes on to say that the particular exchanges weren't enough. That's the first bit of 78. So in 78, he's giving out reasons why they weren't enough. And for our purposes, the last one, 5, is relevant. Even on Nautica's account, and even if the supplier's approval subject bore the meaning for which Nautica contends, at the end of the 13th January exchange, there remained a subject which it was for Trafigura to lift. This is the importance of what type of a thing is it? Is it a thing that remains to be lifted by a contracting party, or is it on a third-party condition, an external event condition? And he held that in this case it remained a subject which it was for Trafigura to lift before a fixture would be concluded, consistent with the general status of such subjects in charter party negotiations. This was a precondition, as much after the 13th of January exchange as it had been when included in the preliminary recap. So the key point, part of the reasoning, is not to do with the sandwich at all. By this stage, there isn't a sandwich. There's only the one subject left. And the reliance is that the two key things are that the type of subject it is, it's one that's to be lifted by a contracting party, not an external event type condition. And secondly, the general status of such subjects in charter party negotiations. And both of those points apply with full force in my submission in the present case.
It is odd, though, isn't it, that all these expressions you say mean the same thing, i.e. no contract, but parties nevertheless choose to use all sorts of different expressions, which then feature in the law reports.
They give a commercial signal, but when analysed legally, the position is as the Lordship says. Perhaps it's worth reiterating the point that Mr. Justice Steyn made in the KKK case, is that this way of going about things makes it very clear when there is a contract and when there isn't, and it avoids dispute. It avoids the sort of dispute that was run in the Leonidas. Oh, well, you haven't made reasonable endeavours. Whether a subject is lifted or not will be clear because it's done in express communications. We send a telex or email saying we lift subs. You know, it's done expressly. There's an absolutely clear point in time at which a contract does or doesn't come into existence. Once one goes down the realm of moving away from that and saying, well, there is a contract and there's some obligations, it's a recipe for litigation. You have to get into questions of who is the supplier, what if there's more than one, how much effort you have to make, the same reasoning that Mr. Justice Steyn found persuasive in relation to subject to details, I submit, and has already been decided in relation to subject to STEM, applies in my submission to other subjects commonly used in charge party negotiation. This is what Mr. Justice Foxton held in the Leonidas, that this is the general status of such subjects. And I would urge the court to be very cautious in disturbing that conclusion, because it would be likely to lead to much more litigation rather than less. I've gone slightly out of order, but I will go back to where I was on. There's a general point about the way Mr. Young puts his case, which is the court was very alive to this, is that the use of the word agreement can be slippery. There is a difference. It's important to distinguish between agreeing on the wording of a term or clause that you are willing to be in a contract if and when it's concluded, and actually entering into a contract in those terms. The slipping from one to another was a constant feature of Mr. Young's submissions in my submission, and also in his skeleton. There are many passages. For example, he says that the parties did, as a matter of fact, conclude an arbitration agreement cannot be disputed. Of course, that is the main dispute. We do dispute that. It's not a question of fact. There is no factual dispute in this case. It's a common ground that the recap accurately represents where the negotiations have got to. The only question is, what does it mean? Does it mean that a contract has been concluded or not? And we say no. Obviously, it didn't. It's in bold. Mr. Young even said, oh, it might be an accident. It's in bold. It's not an accident. I mean, it wouldn't make any difference if it wasn't in bold. But nonetheless, they did put it in bold. And the answer is very clear. There isn't a contract yet. The whole point of the subject is to prevent one. And the reason we wanted to prevent one is because we didn't have a secure inward contract. And we never did get an inward contract because the shipper wouldn't take the ship. And now they want to hold us bound and say we're repudiating it for not chartering the ship. Well, we've got no commercial purpose for the ship, and we protected ourselves with a subject, which is what one does. It's a day in, day out common practice in the chartering market. And the fact that we're now ended up at the third level of judicial or arbitral decision making is really quite remarkable. But nonetheless, they say, Mr. Young's counsel said the parties' agreement was, as a matter of fact, concluded on the 25th of August, as evidenced by a recap. The charterers cannot and do not say otherwise. It's the same point. It's this same slipperiness as to what one means by the word agreement. I mean, of course we dispute there was a contract. That's what the whole case is about. But if he wants to say, oh, there was an agreement in fact, that just means an agreement as to what we might, if we did contract, be, or what we were, if we did contract at all, be willing to contract.
Right, well, I think we understand the parties' positions on that.
I know. I'm sorry, well, I'm labouring it. A slightly different way of, a different angle on this is, I've already made the point that in my submission, Mr. Young is misusing the severability principle in a way that it's not designed to be and can't analytically be used. But the effect of his submissions is also to ascribe to commercial parties, in my submission, unrealistic intentions of dealing with the arbitration or potential arbitration agreement and potential main contract as two separate things that may come into effect at different times, when in all normal circumstances, the parties will be, who are negotiating a written agreement with an arbitration clause, will be dealing with them together, and they won't expect them to be behaving differently. They either agree the contract with its arbitration clause or they don't. And this is a point which is, the judge referred to Enker, the Enker decision in this context, and of course that case was on a different topic, but it's nonetheless interesting in what the Supreme Court said about the separability principle and the limits within which it should be kept. So I would like to refer you to that, please, at tab 10 of the authorities bundle. In the decision of the majority, at paragraph 53, uh, 53.4. This is the context is consideration of the extent to which the separability principle is relevant to whether the arbitration agreement might have a different governing law than the main agreement. This is a section considering the reasonableness of a general rule of construing the choice of law for the main contract to also apply to the arbitration agreement. And the fourth point in Little Roman 4 is the majority is saying that a general rule of that nature avoids artificiality. The principle that an arbitration agreement is separable from the contract containing it is an important part of arbitration law, but it's a legal doctrine, and one which is likely to be much better known to arbitration lawyers than to commercial parties. For them, a contract is a contract, not a contract with an ancillary or collateral or interior arbitration agreement. They would therefore reasonably expect the choice of law to apply to the whole of that contract. The context is different, but the point is the same, that when parties are negotiating a contract, they're dealing with it as just a contract, even if it has an arbitration clause in it. And there's a further passage which was cited by the judge, paragraph 61. And this is disagreeing to some extent with the Court of Appeal. The Supreme Court concludes that the Court of Appeal put too much store by the separability principle in the context of the governing law question. And 61, it begins, the Court of Appeal justified its approach. And this was said to follow from the doctrine that the arbitration agreement is separable from the rest of the contract. In our view, this puts the principle of separability too high. And further on, between B and C, it does not follow from the separability principle that an arbitration agreement is generally to be regarded as a different and separate agreement. At 62, they say that earlier cases need to be seen in their context as ways of expressing the doctrine that discharge by frustration or other reasons of the substantive obligations in the contract won't discharge the agreement to arbitrate. The arbitration clause is nonetheless part of the bundle and rights and obligations recorded in the contractual document. And then further down there's the quotation from Sul America that I already referred you to. So this case is emphasizing the limits to the principle and the limits of the extent to which it's helpful to refer to the principle when considering the intentions of the objectively manifested intentions of the parties. The context there was governing law, but in my submission it's equally relevant in the context of contract formation, whether a contract's concluded. Mr. Young's approach, if it were correct, would have very far-reaching consequences well outside the realm of charter parties, and because it was put to him by the court, perhaps more than once, that does this mean that whenever parties negotiate under a subject contract or equivalent wording, that an arbitration agreement, if they pass drafts backwards and forwards and the wording of the arbitration agreement is no longer being negotiated, both sides are ostensibly happy with it, does this mean that there will always be, they will have always entered into an arbitration agreement? Mr. Young was a little reluctant to say yes, but he equally couldn't say that it wouldn't mean that, or he couldn't give any clear answer as to when it would or it wouldn't. But that is exactly what the point is here. If you accept the premise that the subject here was a precondition, that it is functionally equivalent to subject to contract, which, as Mr. Justice Foxton and Mr. Justice Jacobs held. If one starts from that premise, then this is exactly that case where it's being said that parties expressly negotiating subject to contract nonetheless are to be viewed in law as having concluded an arbitration agreement. That would be a very strange outcome. It would be, I mean, there are all sorts of contexts where parties negotiate expressly subject to contract, whether it be land sales or whatever. This would be a really quite revolutionary approach to when an arbitration agreement is viewed as having been formed and the circumstances in which it can be, will be viewed as having been agreed to by the parties. Mr. Young's arguments were tried before in the Pacific Champ, and as the judge said, the arguments run were, I can't remember if he used the word identical or materially identical to the arguments run by Mr. Young. Now, Mr. Justice Eder was not wrong for the reasons he gave. Unless your lordships would like me to, I don't intend to take you to the case. But I would like to take you to a Singapore case where exactly the same arguments were run and exactly the same result was reached. This is a case called BCY. It's in my authorities tab 3. And this is a case which really does illustrate the sort of arguments Mr. Young is running and why they should not succeed in my submission. And the analysis in the judgment is in my submission useful and relevant to our case. So this was a case of negotiation of a share purchase agreement, and well, you can see if you turn to paragraph 11, there's an offer in which Y writes to the plaintiff offering to purchase shares, and the offer is subject to, among other things, execution of a mutually acceptable SPA, and so the relevant exchanges occur subsequently in the context of trying to negotiate the SPA. And what happens in outline is that various drafts get passed backwards and forwards. I'll show you. Paragraph 14, you can see the second draft SPA is where an arbitration agreement was included. And it's a very widely drawn arbitration agreement. 9.13.2, it expressly includes disputes regarding the existence, validity or termination of the main agreement. So that was the second draft. There's paragraph 16, it says the fourth draft is circulated and there are a couple of amendments to the arbitration agreement. That's in the fourth draft. And then in the end of that paragraph 16, it says there were no further amendments to Article 9.13, that's the arbitration agreement, arbitration clause, sorry, I should say, in the subsequent draft SPA. So there's a fifth draft at 17, then there's a sixth draft. And what one of the parties is going to try and say is that when the sixth draft was sent, together with a covering email that said from the plaintiff's investment specialist, which said it was ready to sign, that's on the 18th of July, the case that's going to be made is that that gave rise to an arbitration agreement. But what happened subsequently is that paragraph 20, a seventh draft is circulated, but that contains significant changes, and then one of the parties pulls out, and nothing is ever signed. So nonetheless, the case sought to be made is that a binding arbitration agreement was nevertheless concluded because of the willingness expressed on the 18th of July to contract in the terms which included an arbitration clause. So it's exactly on point in terms of its substance.
Did you mention it was subject to New York law?
Yes, I'll come to that. Mr. Young correctly points out that it was held that the main contract is governed by New York law, and ultimately it was held. A lot of the judgment is about what's the governing law of the arbitration agreement. That's the same point as in ENCA. Actually, this judgment is referred to in ENCA approvingly in that context, not in this context. So it's Mr. Justice Chong, as he then was in Singapore, and paragraph 1 in itself is very interesting. When the jurisdiction of an arbitral tribunal is challenged on the basis that there is no binding arbitration agreement, the usual ground for such a challenge is that the contract which incorporates the arbitration clause was itself never concluded. In this familiar situation, it has been held that the validity of the arbitration agreement and the existence of a binding contract would stand or fall together, and the court would usually determine both issues collectively. And the reference is to Pacific Champ and to a Singapore case which it appears has followed Pacific Champ. Paragraph 4, interesting, the defendant's case is that a binding ICC arbitration agreement was concluded before the conclusion of the SBA. In advancing this case theory, the defendant argued, relying on the doctrine of separability, that the arbitration clause is separate from and independent of the SBA. So that's what is put. And while we're on this page, towards the end of paragraph 5, there's a big dispute between the parties as to whether it's Singapore law or New York law governing the arbitration agreement, and the judge says that the contest was misplaced simply because both parties acknowledged during the hearing that there was in real and practical terms no material difference between the two, insofar as they relate to the only substantive issue, which is whether an arbitration agreement was formed. But nonetheless, there are pages and pages of analysis of which is the right governing law, and the judge holds that it's New York law. It's complicated. The governing law thing is complicated because, of course, the theory is that this is a freestanding arbitration agreement. So then how does the main contract law, does it relate or not relate? But this is not the relevant point for us. So at paragraph 60, there's a reference to the separability doctrine. The suggestion that the arbitration agreement is a distinct agreement with a governing law distinct from that of the main contract is often justified by the doctrine of separability. However, the doctrine of separability serves to give effect to the parties' expectation that their arbitration clause, embodying their chosen method of dispute resolution, remains effective, even if the main contract is alleged or found to be invalid. It does not mean that the arbitration clause forms a distinct agreement from the time the main contract is formed. So again, a reference to the purpose of the doctrine of separability, of preserving the validity of an arbitration clause, protecting it. So entirely in line with my earlier submissions. 61. Separability serves the narrow, though vital purpose of ensuring that any challenge to the main contract is invalid does not in itself affect the validity of the arbitration agreement. And as a reference to Lord Justice Morbick and Sud America, which I've shown you already, it's one thing to say that under the doctrine of separability, a party cannot avoid the obligation to submit a dispute to arbitration by merely denying the existence of the underlying contract. It's quite different to say that because of this doctrine, parties intended to enter into an arbitration agreement independent of the underlying contract. This does not reflect commercial reality. There's a further sentence, and then the last sentence on this page. In any event, that is, arbitration agreements, are typically negotiated as part of the main contract, and hence are unlikely to be negotiated independently from it. Then moving on to paragraph 77, or 79 perhaps, Mr. Jeremiah also submitted, he's trying to say that there was a concluded arbitration agreement. The doctrine of separability supported his argument. However, as I've explained, the doctrine is only relevant where an arbitration agreement forms part of a main contract. And the function is, doctrine prevents a party from impugning the agreement simply by alleging the main agreement was invalid. In this case, Mr. Jeremiah's case is that the arbitration agreement was concluded before the conclusion of the SPA. There is no need to invoke the doctrine of separability. The court's task in deciding whether the arbitrator had the jurisdiction to hear the dispute is to consider the usual requirements for the formation of a contract under the applicable law. Now that is the same position, on my case anyway, in which we are here. If I'm right about the subject being a precondition to a main contract, then what Mr. Young is contending is that a freestanding arbitration agreement was agreed. That is, an arbitration agreement was agreed before the main contract. Of course, the main contract was never agreed. And 82, New York law, contract is formed where there's offer, acceptance, consideration, mutual assent, intention to be bound. Court must look to the objective manifestations of parties. In 84, although the plaintiff proposed to substitute an arbitration clause in place of the choice of court clause in the second draft, this reference to when the arbitration clause was first proposed, it does not follow that it intended to be bound by the arbitration clause independently of the SPA. the introduction of the arbitration clause was clearly part of the negotiations over the SPA. It was, after all, only one of the revisions which they proposed. The point's not decisive. The key question is whether the parties intended to include an independent arbitration agreement giving rise to binding rights and obligations absent a concluded SPA. That is the hurdle which, in my submission, Mr. Young would have to meet to achieve a concluded arbitration agreement in this case. Similar point in 86, and the 86 reference to New York law, and a quotation from there's a textbook that's quoted, and my submission is equally relevant to English law. In many instances, it would be difficult to show. Perhaps I just ask the court to read the marked passage from the textbook.
Yes.
So in my submission, it's convincing and entirely applicable in our circumstances. Over the page 288, Fiona Trust relied upon it. All the same arguments as my learned friend. 88, attention drawn to Lord Hoffman's speech in Fiona Trust, and reliance on the paragraph 18 that we've looked at, and the judge's response to this reliance on that at 89 is the challenge to the arbitration clause in that case took the form of a challenge to the validity of the main contract on the grounds that it had been procured by bribery. Given that the arbitration clause was not impugned on the basis that the main contract was not concluded, this observation takes us no further than the question of what it means for an arbitration clause to be agreed, whether that means agreement to the wording of the clause or agreement to be bound by it. And that's exactly right in my submission. Lord Hoffman's is the passage we've already looked at. The key words are if the arbitration clause has been agreed, and that means if it's been agreed contractually. The underlying principle, as I found, is that agreeing to the wording of the arbitration clause does not per se equate to an intention to be contractually bound to arbitrate, absent the conclusion of the contract under which the arbitration clause was negotiated. And then finally, just for reference, 96, he deals with a submission in relation to the scope of the arbitration clause, because it said that the scope is very wide. And I just draw attention to the last sentence. The inclusion of the words, that is, words expressly saying that the validity of the main contract can be arbitrated, clarifies the scope of the arbitration agreement, but does not go any way towards answering the question of whether it was meant to be contractually binding absent the conclusion of the SPA. And in my submission, that's logically entirely right. The question in this case is not how wide is the arbitration clause. I have not taken any point on the width of the arbitration clause as a matter of construction. That's why it's not referred to by the judge, and that's why it's not a live issue in this case. I don't. If there was a binding arbitration clause, I don't try to say that it's not wide enough as a matter of its scope to cover initial invalidity. That's not the point at all.
Right. Yes.
Well, Lord, I think that's all. My lords, I think that's all I was going to say on separability, unless there's anything on that topic that you would wish me to address more. One-stop shop principle of construction. There's very little to add here to what I've already said. That is a principle that's relevant to a concluded arbitration agreement, and the foundation of it and the justification for it is the fact that the parties have contracted to arbitrate. That is why it is then reasonable to assume that they wish all disputes of whatever nature to be decided by one tribunal, by the arbitral tribunal. But it can't be of any it's the same point that just arose in that case we looked at with the final sentence. It's logically irrelevant to the question of was an arbitration agreement concluded in those terms in the first place.
Well, you say you don't want to be in any shop.
Sorry?
You say you don't want to be in any shop.
Yes. Well, we don't want the arbitrators to decide anything. It's not a case. There's part in my learned friend's paragraph where he says in the skeleton, well, parties can't possibly have intended some issues to be decided by the arbitrator and others not. That's not my position. My position is we didn't intend anything to be decided by the arbitrators because we haven't agreed to anything contractually.
Yes.
So I'm not sure that I can usefully add much on that. So that's really limb 2 when I looked at the grounds of appeal was the one-stop shop construction principle. And then the third point is, the third topic is construing the fixture recap as a whole and whether the subject should be cut down so as to there to be an obligation that it can't be unreasonably withheld. In my submission, the judge dealt with this, as indeed with all the topics in the case, admirably, and I'm not sure I can usefully add to his discussion, which begins at paragraph 118 of the judgment. The first point he makes at 118 is that the subject is expressed in unqualified terms. Perhaps it's helpful for these purposes to turn up the recap. I mean, your lordship's already seen the subject. It's emboldened at the start of the document. It doesn't contain any restrictions on the lifting or the lifting of the subject or the giving of the approval. If that's what the parties had intended, in what is obviously intended to be a very important provision, that's why it comes first, that's why it's in bold. If they had intended to be cut down in a very material way, it is to be expected that they would have provided for that. And of course, they haven't. It's just in an ordinary form of saying shippers, receivers, approval. The express language, therefore, is against my learned friend. And to get his argument off the ground, he has to resort to wording in the pro forma charter party that's conditionally incorporated into this recap. And I mean, I refer your lordships to all the points the judge makes, and I'm not sure I do need to go through all of them, but it's just conceptually entirely the wrong approach. This wording at the outset of the fixture qualifies everything that follows. It qualifies the agreement to arbitration, it qualifies the incorporation of the charter party. Every single term that follows, or proposed term, is subject to this. And so it has an inherently superior status to all the other provisions of the fixture because it is objective meaning is to qualify the nature of my client's agreement to anything, and qualifies in a way that means it's not a contractual agreement. It's a subject to contract wording. That's what it's meaning, and that's consistent with the ordinary meaning of such subjects in charter party negotiations. All the points arising from the Leonidas, and to try and cut it down, and not even by reference to another term in the recap itself. My learned friend has to go one level further away by referring to the conditionally incorporated pro forma, which is only relevant because of the wording in clause 20 of the recap, which says otherwise as per charter's pro forma, clearly giving express preeminence to the wording of the recap as against the pro forma. Nonetheless, his submission is that the wording of the pro forma overrides and cuts down very materially the nature and scope of the subject. It's just not a realistic submission in my submission. And then there's the further point that the particular provisions in the pro forma that he relies are all entirely irrelevant in my submission to this contract. The point my Lord Justice Mayles made, that they're all, the pro forma is for a vessel to be nominated. That's not our case. It's for an identified vessel. There is no nomination. All those procedures have nothing to do with the proposed contract in this case, which is for a specific vessel. So not only because of the word otherwise, that means it's only conditionally incorporated anyway, but also because by its nature it's not appropriate to read it in or to cut down the wording of the subject for that. So the judge said he was inclined to consider that the arbitrator was obviously wrong on this point. And he was right to do so. It is an entirely mistaken approach to construction of the agreement. My lords, unless there's anything I can assist you with further, I think that's all I need to say.
No, well, thank you very much, Mr. Howard. Mr. Young?
My lord, my learned friend made a comment in response to my Lord Justice Mayles' point about, as it were, the mess that was made within the charterer's side, which allowed the arbitration to proceed. Do you remember that point?
Mm-hmm.
My learned friend said, yeah, well, if there hadn't been the mess, I'm paraphrasing him at this stage, submissions would have been made to the arbitrator and we would never have been here. That was a very telling observation, because any commercial man looking at this recap would have said, yes, we better make submissions to an arbitrator. That's my learned friend's depiction of what would have happened is a very illuminating insight into the way that these things should work. Now, my lord, my learned friend made a submission that the purpose of the separability doctrine is to protect arbitration agreements from the existence or invalidity of the main agreement. He then showed you authority which he said supported that proposition. In my respectful submission, there is no occasion in any of the authorities to which he referred which says the purpose is to protect arbitration agreements. He showed you a passage in the judgment of Mr. Justice Steyn, as he then was, in tab bundle, second bundle, tab 4, in Harbour and Cancer. And he showed you the passage at page, I think it's 46 of his second bundle, page 86 of the report. And he cited what Mr. Justice Steyn said. The right-hand column, the paragraph beginning the foundation. And he said, for example, if the clause is whether a party were ever assented to a contract containing an arbitration clause, the issue, lack of consensus, impeaches the arbitration agreement. Similarly, the arbitration agreement itself can be directly impeached on the ground that the arbitration agreement itself is void for vagueness, void for mistake, avoided on the ground of misrepresentation, duress, and so forth. All such disputes fall outside the scope of the arbitration agreement, no matter how widely drawn. Now, that is a remarkable submission to make in the light of the judgment of the House of Lords in Fiona Trust, which said all disputes arising out of the relationship created, whatever that relationship should be, should all be decided by the same tribunal. With the greatest of respect, that particular passage in Mr. Justice Staines' judgment was not approved by Lord Justice Hoffman, as he then was, or Lord Justice Leggett, and it actually sits extraordinarily uncomfortably with Fiona Trust, both as a matter of policy and as a matter of construction.
It's a bit odd, though, isn't it, if the Court of Appeal approved Mr. Justice Staines' reasoning on this part of the case, used the language of impeaching, which seems to come from here, and then in the House of Lords in Fiona Trust, much the same language is used, but nobody ever says, but although we're saying all this, Mr. Justice Staines got this bit wrong.
Well, if anybody had been addressing that point, then obviously they would have considered it. But if I may respectfully say so, the view formed by the House of Lords was you've actually got to create a completely new starting point. I mean, that was the... I think if one asks what Fiona Trust was actually achieving, it was a complete break from the past and a new approach to arbitration and
on the construction of arbitration clauses and all the, I think the word was fussy distinctions.
That was Lord Holmes.
Yes.
Yes. Yes, absolutely. But what they did say was the natural instinct of commercial men is that all disputes arising out of the relationship should be decided by the same. Let's just take the issue of a subject, or a subject of a third party's approval of a vessel. What on earth does that have to do with arbitration? Nothing. It may or it may not be a condition precedent to the main contract. Mr. Justice Foxton says you can have third-party approvals which may or may not be conditions precedent or maybe performance conditions. It's a difficult question of construction and very often application of particular knowledge. And I think my Lord Justice Birss, in a sense, put his finger right upon the conundrum which lies at the heart of my learned friend's case. He said, well, if one party thinks that a particular term is a performance condition and another party says it's not, what does the party who is relying upon the performance condition and by necessarily making the claim, what does he do? He then goes to arbitration. And the way it should then be dealt with is that the arbitrator should decide that issue subject to Section 69 appeal. And it's, in a sense, the question before your lordships is what is the appropriate role of the courts in intervening in the arbitration process? That's the central question. And we know, because ever since the Act, the need, the desirability for curial intervention in arbitration is not popular. One of the issues going to be considered by the Law Commission, I think at the moment, they take the view that Section 69 is working very well. The view of some that you shouldn't have any curial intervention in arbitral proceedings at all, and your lordship will know that that's certainly the position pretty much in the United States.
Well, Mr. Bourne, who might be taken as a representative of the international arbitration community in the sort of supra-jurisdictional
Mr. Bourne
seems quite happy with Mr. Holroyd's submissions.
Yes. Mr. Bourne, I'm sure your lordship knows, is a man of very very clear and strong views that are not necessarily held by others. But in my respectful submission, the essential question for your lordships today is whether, when you've got a row, a dispute arising out of a relationship between two people as to whether there was a binding contract, or whether a subject had been lifted or waived, or somehow communicated wrongly, or whether the lifting was induced by error, fundamental mistake, that there should be two mutually inconsistent dispute resolution tribunals to decide that. That's what the House of Lords said you should try to avoid. They said there may be clear cases where that is inevitable, but you shouldn't bend over backwards to create a bifurcated system, which will inevitably be so if your lordships accede to my learned friend's case. Because let's take the example of a subject such as this, a third party approval, which is commonly regarded as a performance condition, as Mr. Justice Foxton accepted.
Sorry.
Where did he accept that? Just bear with me. Para 49 of Mr. Justice Foxton in the Leonidas. I accept Mr. Pearce's submission that an important factor in determining whether a subject is a precondition or a performance condition is whether the satisfaction of the subject depends upon the decision of a contracting party or that of a third party. And then at 52 he says, each case will depend upon its own individual facts and commercial context. It is clear that a subject is more likely to be classified as a precondition rather than a performance condition if the fulfillment of the subject involves the exercise of a personal or commercial judgment by one of the imputative contracting parties. So he's saying where you have a third party determination of the what is or is not the subject of the subject, then it's more likely to be a performance condition than if it's where one of the contracting parties is considering the commercial desirability. And one has here two levels. There's firstly, is it a contracting party who's considering the commercial desirability of the main contract? And then, is the subject, which is the way that the parties have expressed themselves, is that subject referable to arbitration? And that's why when you see the House of Lords saying the clear words must relate directly to the arbitration agreement, you ask yourself, what on earth is, as I said, I've said this before, what on earth is the relevance, still less the impeaching quality, of a third party's view about the vessel? Does that somehow show that they didn't wish the arbitrators to consider it? That's absolutely the paradigm of what arbitrators do consider. But just take the case where there's a subject of this sort, which may be a performance condition, it may be a precondition. And then there's an argument about whether it had been waived by conduct or words. Let's suppose, in fact, that the ship owner had said, well, I'm going to sail off. And the charterer had said, well, I waived the precondition. I waived the subject because the commercial circumstances were such that it was commercially desirable for me. Issues of waiver going to court on matters of jurisdiction with the greatest of respect. That, once again, is the paradigm of what arbitrators deal with. And so it's this division of types of dispute which are or are not to be decided by the arbitrators, which is absolutely the antithesis of what the House of Lords was saying in Fiona Trust. And it's absolutely that division of jurisdictional focus that underlines and undermines my learned friend's own position. And he accepted, I think, that essentially any subject, I think it was in response to a question from my Lord Justice Snowden, any subject somehow precludes an intention to create legal relations, both as to the main contract and the arbitration agreement. Well, and this comes back to my Lord Justice Birss's point. Hang on, not any subject, because some subjects are performance conditions. So he can't just say, oh, well, if there's a subject, there's a precondition to the contract, and that is it. Because it may or it may not do. But what you should do is ask yourself, does that subject prevent the arbitration agreement that has been made in the agreement to the terms? Has that been somehow excluded? And it's jolly important. My learned friend said, well, what happens if you have a lot of offers and counter offers and acceptances and whatever? It's not at all unusual to have questions of offer and acceptance referred to arbitration without a whimper of a jurisdictional issue. But let's suppose, my lord will be familiar with the way that shipping brokers, at least, negotiate their deals, that they have what are called accept and accept responses. You can have the situation where we accept, A presents a set of terms with an arbitration agreement, and the response to that is accept things that don't relate to the arbitration agreement at all. So actually what both parties have done is accepted the terms of the arbitration agreement and accepted the role of the arbitration agreement. And the arbitration agreement being separable and a collateral contract, that has concluded that contract.
So your submission then is an accept response which does not take a point on the arbitration agreement, amounts to the conclusion of a binding arbitration agreement.
Yeah. That's right. And there's nothing unrealistic or unanalytic about it. Because it is a separate agreement, that agreement has been concluded. Absolutely.
So notionally, the message to which that is a response should be analysed as the making of two offers, one to conclude a charter party main contract and another to conclude a separate arbitration.
Well, I see no difficulty when one has to bear in mind that the two are separate contracts. I have no difficulty in saying that that is actually right. And what on earth, as a matter of policy, is wrong with parties who agree arbitration of the disputes arising out of their relationship, then having disputes which may or may not arise as to how and on what terms the resulting contract was concluded being referred to arbitration. Your lordship knows that it is very common in cases of this sort that one of the issues before arbitrators is, well, what were the terms actually agreed? The terms of the charter party. I'm not actually sure that I haven't appeared before your lordship as an arbitrator on such a case, but maybe I'm wrong.
If so, that was in the dim and distant past, and I have no recollection
but
of it.
It is the paradigm of arbitrators looking at offers and acceptances and working out what are the terms that have been agreed or have not been agreed. But as long as there is agreement to arbitration of such a dispute which arises out of the relationship, which may or may not be a contractual relationship, then yes, it's an arbitration agreement has been concluded. You then have to ask yourself, as a matter of construction, what is the impact of that arbitration agreement? My learned friend said I've been unclear about what I say is an agreement. With the greatest respect, that's profoundly unfair. I was trying to use an untendentious way of expressing it. There isn't, and I hope I made that plain when I was answering the questions from my Lord Justice Snowden. I was trying to avoid the very issue that my learned friend says I was somehow unclear about. I was trying to avoid referring to a contract or a non-contract. I was saying it's just an agreement. Whether it's binding or not is a matter of law. But that's profoundly unfair. So the issue is when disputes arise out of the relationship between these parties, whatever may be the disputes, does their factual agreement to arbitrate those disputes, does it somehow become immaterial so that everybody can rush off to court on a Section 67 and decide, and depending on how it's decided, then come back on an appeal? If I may respectfully say so, the policy of Fiona Trust is, no, let it all be decided by arbitration, and there is a route of appeal which should be followed. And indeed, that's exactly what my learned friend has done. He's just tried to ride two horses by saying, well, Section 67, and if that fails, Section 69. No, that's to abuse the Section 67 procedure in my submission. What he should have done was Section 69. It may be that he might win Section 69, it may be that he might lose it. But the appeal is the right way, and that, in fact, is the way that the Law Commission are looking at it, that any curial involvement on a Section 67 should be by way of appeal. There's a question of what they mean by appeal. That's been taken up with them. So, but it's precisely to avoid this fussiness in carving up different sorts of dispute which can be referred to different tribunals, that the House of Lords have set out the clear presumption, not just a clear presumption as a matter of construction, but a clear presumption as a matter of policy. And if, at the end of the day...
So where do you say, I understand I understand exactly where the House of Lords set out a presumption as a matter of construction. Where do you say they set out the presumption as a matter of policy?
Well, the same... the policy is one stop.
As regards severability?
Well, I think I've immediately got Lord Hope in mind at page 88 of the bundle, 961 of the that deals with fussiness.
Yes, that's
and then
that's in the section on construction.
Yes, on fussiness, and then over the page 28, para 28.
Still in the section dealing with construction.
Well, I see that, my lord. Really, it goes to I think probably then 964. The doctrine of separability requires direct impeachment of the arbitration agreement before it can be set aside. This is an exacting test. Now, that is really a statement of principle, and if I may respectfully say so, the thrust of Lord Hoffman's speech is to the like effect. I think your lordship identified paragraph 18, although it's going to be said that that's to do with construction.
No, 18.
Paragraph 19.
No, 18 is to do with separability.
Separability. Yes, and then paragraph 19.
But I don't see where they there erect a presumption to which you say that. Sorry, I do not see where there is a presumption in those paragraphs dealing with separability.
Well, that's why I was momentarily perplexed by your lordship's question as to whether there was a presumption in relation to separability. The answer is that, as expressed in those terms, the terms in which your lordship has put it to me, he doesn't. What he does do is to say there is a policy of the law that where parties have agreed that their relationship shall have disputes, or disputes arising out of their relationship shall be referred to arbitration, then it's all disputes, not just some of them, not void.
No, I don't dispute that, but that's as a matter of construction of the agreement they have made.
Now, I see that. I see that, my lord. And if your lordship is wanting something more, then I don't think I can give you that. But you can see the policy is written through this both speeches as a watermark. That the policy is to have one stop dispute resolution, and that is a matter of policy. Now, I think my learned friend was.
So just following that up,
yes,
I was going to ask you at the end, but I might as well ask you now. So the paragraph you drew our attention to in Mr. Justice Staines' decision in Harbour
and Cancer, yes,
at page 86 of the report, the sidelined passage on the right-hand side that you were asked questions about. If you're right in the submission you've just made, all of that's wrong, isn't it? I mean, or let me put it slightly differently. Could you walk me through that paragraph and tell me which, if any, sentence you either agree or disagree with, and say, what's right or what's wrong? Because it follows from what you've just said, I suspect, that you'd say it's all wrong.
I've got one qualification. I do say that it is out of kilter with what said, but where one says, similarly, the arbitration agreement can be directly impeached on the ground that the arbitration agreement itself is void for vagueness, void for mistake, voided on the ground of misrepresentation, duress, and so forth. If all he's saying is that that is a fundamental attack on the arbitration agreement, not the underlying agreement, then there's nothing wrong with
Well, that's what he is saying. He says the arbitration agreement itself
yes,
can be directly impeached. I mean, because you're not saying, are you, that an arbitrator can decide for himself whether the arbitration agreement under which he is purportedly appointed is void for uncertainty.
Strangely, that does happen. That's exactly what arbitrators do sometimes.
So if the argument is that this arbitration agreement is too void, is too
void
vague, is void for uncertainty, you're saying that self-same arbitration provision can authorise the arbitrator to determine that.
And that works under Section 30 of the Arbitration Act. Yes, competence. Yes, absolutely. But the point is, do I accept that matters go impeaching the underlying contract for vagueness, mistake, misrep, duress, and so forth? Yes, I do say that's wrong. If you limit it to matters which are specifically directed towards the arbitration agreement as it has been, that term has been agreed in a fixture recap, then I don't. So I suggest that one has to be very cautious in reading that judgment to say that issues of voidness for mistake, misrepresentation and the like aren't arbitrable. They very often are. And it's only those issues which go directly to the arbitration agreement itself that where there is scope for Section 67. But it's got to relate to the arbitration agreement itself. And that is where I come back to the point that I've made before, which is this is a third party's approval of a vessel. And that does not in any way relate to, still less does it impeach, the agreement of the parties to the charter fixture, whether binding or not, as to who determines the dispute. And it's all about who determines the dispute when it arises.
That's a question of the meaning of, or the scope or meaning of the subject provision.
Yes, I would not deny that, but you ask yourself, what have the parties agreed arbitration of that dispute? Answer yes, I would submit, because that subject does not directly impeach or directly relate to or directly go to the parties' agreement to arbitrate. I intentionally did not develop an argument on subject board approval or the like, or subject to contract, because they may present different considerations. But when you've got a subject of this sort, which is capable of being either a condition precedent or a performance condition, which has got nothing whatsoever to do with the arbitration of disputes, then it does not and should not, as a matter of construction of the whole, or as a matter of policy, deprive the arbitrator of jurisdiction. And it does matter as to which tribunal decides it, because of the need for fact-finding. One of the issues that the Law Commission dislikes about Section 67 is that parties can have two bites at a cherry. I think they said that they think it's quite wrong that a party can fight before an arbitrator while reserving jurisdiction, have its weaknesses in its evidence identified, and then get those failings corrected before the court. They said that's deeply unacceptable. And that's deeply unacceptable because there should be a one-stop process. So you, my lords, have within your power to determine whether inevitably when you have disputes like this, there is going to be a two-stop process, or whether there should actually be a one-stop process. That is the issue of policy and the issue of construction. And I do say that as on the question of construction, I would accept that it's the question of construction of the subject relating to rightship documentation and the arbitration clause, for want of a better term, that has to be construed. But you should construe it in the light of what the owner trust says, and not treat the main agreement and the arbitration agreement as standing or falling together. They absolutely don't, and they should not. It's gone to 4:15. I think I'm going to be repeating myself to the extent that I haven't already done so.
All right. Well,
the reasonable expectations of commercial men is that when they agree an arbitration clause, then their dispute should be arbitrated, whatever those disputes are. Unless I can assist your lordships further, those are my submissions.
Thank you very much. Well, thank you, both of you, and the teams behind you, and those
in China,
those watching on live stream, if they are. We will reserve judgment. I hope that my clerk has been in touch to get from you the identities of those to whom the draft judgment should be sent. I see Mr. Holroyd nodding, but I'll say
I have absolutely no idea.
Well, if she hasn't, she will. As you will know from the Counsel General for Wales case, the court, I'm sure you know, but I'll say it so that everybody can hear it. The court now takes very seriously the sending out of draft judgments and the embargo to which they are subject, and they are sent out for very specific purposes, and only for those purposes until they are handed down. Hand down will be remote. When you get the drafts, we would welcome any typographical or similar corrections, and we would be even more pleased if you are able to agree a draft order for us to consider. If you're not, then we will have short written submissions on any points of disagreement, and we'll resolve them without a further hearing. Thank you all very much.